When I bought the ranch just outside of Willow Bend, I wasn't looking for trouble. I'd spent 15 years on the federal bench, presiding over everything from land disputes to fraud cases, and what I wanted now was quiet. The ranch was supposed to be my escape. Wide pastures, a creek running through the back 40, and a small, sturdy wooden bridge that connected my property to the county road. I still remember the first time I drove across it. The boards creaked a little under my truck's tires, but it held firm. It was the only way in and out, and I liked it that way. A single access point meant privacy and security. The realtor had mentioned that the local HOA was active, but I figured that was just the usual suburban nonsense. I lived on acreage, after all. Surely they wouldn't bother me. For a few months, life was exactly what I'd hoped for. Mornings spent drinking coffee on the porch, watching deer by the creek. Afternoons fixing fences, brushing down the horses, getting my hands dirty for the first time in years. The bridge was part of my ritual. Every time I crossed it, I felt like I was leaving the noise of the world behind. Then, one Tuesday afternoon in early spring, I came home from town to find 3 men standing by the bridge. They wore neon vests and hard hats, and they'd blocked the road with orange cones. "What's going on here?" I asked, stepping out of my truck. One of them, a wiry guy with a clipboard, gave me a quick once-over. "HOA orders. We're here to take this bridge down." I blinked at him. "Take it down?" "This is my bridge," he shrugged. "HOA says it's a safety hazard. Liability issue. We're authorized to remove it today." "The hell you are," I said, stepping closer. "You set 1 foot on that bridge and you're trespassing." The man looked uncomfortable but didn't back down. "Sir, we have paperwork." "Let me see it." He hesitated, then handed me a printed memo with the HOA's letterhead. It was full of boilerplate language about community safety and unauthorized structures. At the bottom was a signature from the HOA president, a man named Carl Benson. I laughed, not because it was funny, but because it was so absurd. "This bridge predates the HOA by 50 years. It's on my land. You have no authority here." The man looked like he wanted to argue, but I must have looked serious enough that he finally muttered something into his radio and waved the crew back. They packed up and left, but not before taking a few pictures. That night, I emailed the HOA board and told them in no uncertain terms to stay off my property. Carl wrote back a day later, claiming the bridge violated community standards and posed a risk to all residents. "All residents?" I muttered as I read it. "Nobody but me uses this bridge." I wrote back and told him to stay in his lane. Literally. For a couple of weeks, nothing happened. Then, one Saturday morning, I heard the sound of machinery. I ran to the porch just in time to see a yellow backhoe rumbling down my driveway toward the creek. By the time I got there, the workers had already chained the bridge and were ripping it apart. I jumped in front of the machine, waving my arms. "Stop! You're destroying private property." The foreman yelled back over the engine noise. "We have orders!" "You have no jurisdiction," I shouted. "Get off my land right now!" But they didn't stop until the bridge was nothing but a pile of splintered wood in the creek. Then they loaded the pieces into a truck and drove off like nothing had happened. I stood there, heart pounding, staring at the wreckage. My only access road was gone. They hadn't just inconvenienced me, they'd stranded me on my own property. That was the moment the switch flipped. I wasn't just a ranch owner. I wasn't just some guy they could push around. I was a federal judge appointed for life, with jurisdiction over cases exactly like this one, and they had just committed criminal trespass, destruction of property, and potentially a violation of federal right-of-way laws. I went inside, poured myself a cup of coffee, and called the U.S. Marshal's office. By the end of the day, I had 2 deputies on my porch taking statements. They photographed the damage, collected the HOA's memo as evidence, and assured me they'd handle it. "You want us to pick them up?" one of the deputies asked. "Not yet," I said, "but I want them served. Fast." The next morning, I drafted an injunction from my own bench. By noon, Carl Benson and every member of the HOA board had been served with federal restraining orders, forbidding them from setting foot on my property, and that was just the opening move. By Monday morning, word had spread through Willow Bend like wildfire. My phone rang 6 times before noon. Neighbors I'd barely spoken to, all asking if it was true that Carl and the HOA had been served by federal marshals. "Oh, it's true," I said. "And I'm just getting started." I called a contractor that afternoon and arranged for a temporary steel bridge to be delivered. They had to use a crane and a convoy of flatbeds to get it installed, but by Wednesday I had access to the road again. When Carl drove by in his SUV and saw the crane lifting the new bridge into place, he stopped and started shouting from his window. "You can't just build whatever you want," he yelled. I walked up to his car, calm as could be. "Actually, Carl, I can. And you should be careful about what you say. You're under a federal injunction." His face turned red. "This is a private community. We have rules." "Your rules stop at my property line," I said evenly. "And after last weekend, you're one more stunt away from contempt of court." He peeled out, tires spitting gravel. I just smiled and walked back to the crew. The next HOA board meeting was standing room only. They'd moved it to the clubhouse, and I decided to attend. When I walked in, you could have heard a pin drop. Carl was at the front, flipping through papers like a man who wished he was anywhere else. I waited until they started discussing community infrastructure before standing up. "Let's skip the euphemisms," I said. "You authorized a crew to destroy a lawful structure on private property without consent or jurisdiction. That's called vandalism where I come from. And because you blocked my sole access point, that's also false imprisonment under federal law." Murmurs rippled through the room. Carl's face was pale now. "You can't threaten us." "I'm not threatening you," I said, pulling a folder from under my arm. "I'm informing you. The Department of Justice is opening an investigation. Every board member who signed off on that order is being subpoenaed. You'll be deposed under oath. If I were you, I'd lawyer up." Someone near the back clapped. Then another. By the time I turned to leave, half the room was applauding. It didn't take long for the HOA to start panicking. 2 of the board members resigned that same week, citing personal reasons. Carl sent me 3 different letters trying to work things out amicably, but I didn't respond. Instead, I turned my attention to something bigger. The bridge wasn't just a convenience. It crossed a navigable waterway, which meant it fell under federal jurisdiction. And thanks to a case I'd ruled on years earlier, I knew exactly how to classify it. A critical access point for an agricultural property. That meant anyone interfering with it could be charged under federal statutes. I filed a complaint with the Army Corps of Engineers, who promptly sent an investigator. 2 weeks later, the Corps issued a formal notice to the HOA. Any further interference with the bridge would result in fines of up to $50,000 per day. I wish I could have seen Carl's face when he opened that letter. But he didn't give up. Not right. Away. One night around 10 p.m., I heard trucks on the road. I grabbed my coat and stepped outside just in time to see 2 men trying to chain the new bridge. "Hey!" I shouted, striding toward them. They froze, then bolted for their truck. I got a good look at the plates before they sped off. The next morning, I handed the number to the marshals. They traced it back to a landscaping company contracted by the HOA. Within 48 hours, those men were in custody, charged with trespassing and destruction of federal infrastructure. That was when Carl finally snapped. He called me personally, ranting about how I was ruining the community. "No, Carl," I said. "You did that yourself when you decided the rules applied to everyone but you. You think you're untouchable because you wear a robe?" He spat. "No," I said. "I think I'm untouchable because the law is on my side. And you might want to start worrying less about me and more about your insurance. Premiums, because every one of your homeowners is about to see them skyrocket when they find out what you've done." There was a long pause on the line. Then he hung up. The next HOA newsletter was an absolute masterpiece of damage control. It claimed the bridge issue had been a miscommunication and that the board was working with local and federal authorities to ensure safety and compliance. Not a single word of apology, but it didn't matter. Everyone in the neighborhood knew what had really happened. I started getting visitors, neighbors I'd never met bringing over pie, beer, or just stopping by to thank me. "Carl's been a tyrant for years," one older man told me. "You've done more to rein him in a month than we've managed in a decade." It was gratifying, sure, but I wasn't done yet. I still had a lawsuit to file. When I sat down to draft it, I didn't just go after Carl. I named every board member who'd signed the demolition order. I named the contractor who'd taken the job without verifying jurisdiction. I named the HOA itself. By the time I was finished, the complaint was 47 pages long and included claims for trespass, destruction of property, interference with access, and punitive damages. I filed it in federal court under my colleague's jurisdiction, a judge I'd known for years. And then I waited. The day of the preliminary hearing, the courthouse was buzzing. It's not every day that a homeowners association gets hauled into federal court, and word had spread beyond Willow Bend. Reporters from the local paper and even a regional news station were waiting by the steps when I arrived. I didn't mind. Let them see. Inside the courtroom, Carl sat with his attorney, a slick-looking man in a navy suit who clearly thought this was just another neighborhood spat. When the case was called, my colleague Judge Mason looked over the docket, then at me sitting at the plaintiff's table. "Unusual to see you on this side of the bench," he said with a wry smile. "Unusual circumstances," I replied. The hearing began with the HOA's attorney arguing that my lawsuit was overreach, that this was a local matter that should be handled in small claims court or by municipal mediation. "Judge, Mason wasn't having it. You're accused of destroying the plaintiff's sole access point to his property," he said, steepling his fingers. "You don't think that rises to the level of a federal claim?" The attorney stammered, backpedaling. Carl shot him a glare. When it was my turn, I laid out everything. The memo authorizing the destruction, the photographs of the wreckage, the marshal's reports, and the Army Corps letter. "This was not a misunderstanding," I said evenly. "It was a deliberate, coordinated effort to interfere with my property rights, undertaken without jurisdiction, resulting in financial loss and safety risk. And it will not stand." The gallery was so quiet you could hear a pen drop. Judge Mason didn't deliberate long. "Preliminary injunction granted," he said. "HOA and its agents are barred from interfering with the plaintiff's property until further order of this court." Discovery to begin immediately. Carl's face turned purple. His attorney put a hand on his arm to keep him seated. Outside the courthouse, the reporters swarmed. "Judge, are you using your position to intimidate the HOA?" one asked. I stopped on the steps. "No, I'm using the law to hold them accountable. What happened to my bridge could happen to anyone, and if you think property rights don't matter, you haven't been paying attention." The story ran on the evening news that night. By morning, my inbox was flooded with messages from people all over the county telling me about their own HOA nightmares. Apparently, Carl's little fiefdom wasn't unique. Meanwhile, discovery began. My attorney subpoenaed HOA board meeting minutes, internal emails, and financial records. What we found was worse than I'd imagined. Not only had Carl pushed through the demolition order without a proper vote, he'd also diverted HOA funds to pay for the crew under a bogus emergency maintenance line item. When confronted with the documents, his own treasurer resigned on the spot. That was when Carl tried to settle. He showed up at my gate one evening in person, looking more haggard than I'd ever seen him. "We don't need to keep fighting," he said. "Let's just drop this. I'll get the HOA to reimburse you for the bridge." "This was never just about money," I said, leaning on the fence. "You abused your position, Carl. You thought you could bulldoze whoever you wanted. You endangered me and my property. There have to be consequences." His jaw clenched. "You're ruining my life over a damn bridge." "No," I said quietly. "You ruined your life when you decided you were above the law." He left without another word. The depositions were brutal. One by one, the board members admitted they'd signed whatever Carl put in front of them without reading it. One admitted she'd voiced concerns but was told to stay quiet or be replaced. Carl's deposition was the worst. My attorney was surgical, pinning him down on every decision, every dollar spent, every step he took to bypass procedure. By the end of the day, he looked like he might be sick. "Do you have anything else to add?" my attorney asked. Carl glared at me. "Yeah, I think you're enjoying this." I didn't answer. The trial date was set for 6 weeks out, but by then the HOA had practically collapsed. 3 more members resigned, leaving Carl and 1 loyalist to run the board. Neighbors started circulating petitions to have him removed. I kept quiet, letting the process play out. The night before trial, Carl's lawyer called mine with a new offer: full replacement of the bridge, reimbursement for all damages, public apology letter to every homeowner, and Carl's immediate resignation from the board. "Tempting," I said when my lawyer relayed it to me, "but we're not done until there's a judgment. Because this wasn't just about me anymore, it was about setting precedent." When trial opened, The courtroom was packed. Neighbors filled the gallery, some standing along the back wall. The HOA tried to paint me as vindictive, as a judge throwing his weight around, but the evidence spoke for itself. We presented the photos, the memos, the deposition transcripts, the financial irregularities. The jury didn't take long. After 2 hours of deliberation, they came back with a verdict, liable on all counts. They awarded me triple damages, legal fees and punitive damages. Carl sat there, stone-faced, as the judgment was read. When it was over, I shook my attorney's hand and walked out without looking back. But I knew it wasn't over yet. Not for Carl. The verdict sent shockwaves through Willow Bend. By the next HOA meeting, Carl's chair was empty. He hadn't shown up since the trial. A notice went out 2 days later that he'd resigned and was moving away to focus on family. I heard through the grapevine that the punitive damages had nearly bankrupted him. His house went up for sale within the month. The man who once strutted around like a kingpin of the neighborhood slunk away under cover of night. But I wasn't interested in revenge anymore. I wanted reform. The first thing I did after the verdict was take the judgment money and rebuild the bridge properly, this time in steel and concrete, with weight limits posted and flood-resistant foundations. I hired a local artist to weld a custom plaque into the railing. It read, "This bridge stands by order of federal court. Trespassers will be prosecuted." It wasn't just a bridge now. It was a monument to the fight. Neighbors started using it as a landmark. "Turn left after the judge's bridge," they'd say to visitors. Some of them brought their kids by just to show them the plaque. But there was still the matter of the HOA. At the next election, a new board was voted in almost unanimously. They were ordinary folks. A retired teacher, a local contractor, a mom who ran the PTA. One of their first acts was to pass a resolution affirming that the HOA had no authority over properties outside its platted lots. Then, they invited me to speak. I stood at the clubhouse podium, looking out at a packed room of neighbors. This wasn't just about a bridge, I told them. It was about boundaries, about the limits of power. We live in a country of laws, not fiefdoms. If someone tells you they can take something from you because it's convenient for them, ask to see the statute, ask to see the precedent. And if they can't show it, stand your ground. The room erupted in applause. That night, for the first time since the whole mess started, I slept like a rock. Carl tried one last desperate move a few weeks later. His attorney filed a motion to have the judgment vacated, claiming judicial bias. The appellate court denied it without even scheduling oral argument. The opinion was only 5 pages long, but devastatingly clear. The defendant's actions were unlawful, willful, and malicious. The trial was fair, the judgment was sound, and this court will not disturb it. That was the end of Carl's crusade. Months passed. The HOA stabilized. The lawsuit stopped. People started smiling at each other again at the farmer's market. My mailbox stopped filling up with threats and legal notices and started getting thank you notes instead. One Saturday morning, I was back on the porch with my coffee, watching a pair of deer cross the creek. The new bridge glistened with dew in the morning light. I thought about everything that had happened, the shouting matches, the court dates, the late-night phone calls with marshals. And I realized something. I hadn't just defended my bridge. I'd defended the principle that a man's home is his castle, and that no HOA, no petty bureaucrat, no would-be tyrant has the right to tear it down without a fight. That weekend, a few neighbors came by with their kids to walk across the bridge. I grabbed a box of chalk and let the kids draw on the concrete decking while their parents talked. By the end of the afternoon, the bridge was covered in hearts, stick figures, and the words "Thank you, Judge" in giant, colorful letters. It was the best compliment I'd ever gotten. Months later, I got a letter from the county commission. They'd decided to designate the bridge as a protected agricultural access point, meaning no local authority, not the HOA, not even the county, that could remove or modify it without a federal order. I had smiled as I read that, knowing it meant no one would ever try to touch it again. The fight had been exhausting, sure, but standing there that evening, hand resting on the cool steel of the new railing, I knew it had been worth it, because the bridge wasn't just standing. It was stronger than it had ever been, and so was I.